He thought calling her name would be the easiest victory of his career, but before the morning ended, Judge Raymond Pierce would learn that the quietest people often carry the sharpest truths. Hello everyone. Before we begin today's story, I have a small favor to ask. Please hit subscribe and turn on the notification bell so you never miss our channel's new videos. It's quick, free, and the best way to support us in bringing you more dramatic stories. Your support means the world to us. Where are you watching from? Drop your city or country in the comments below. Thank you very much. The courthouse in Brookdale, Massachusetts stood like a monument to authority, its granite steps polished by decades of footsteps, and its brass doors gleaming in the cold morning sun. Inside, marble floors echoed beneath hurried shoes, whispered deals, nervous prayers, and the clipped voices of clerks who had seen too much to be surprised by anything anymore. At exactly 8:57 a.m., Judge Raymond Pierce entered through the private hallway behind Courtroom 3, his black robe pressed perfectly, his silver hair neat, his expression carved from practiced superiority. Men with titles nodded when he passed. Women with folders lowered their eyes. Even the bailiff straightened a little taller. Raymond enjoyed those small movements. Respect, in his mind, was something taken, not earned. He paused outside the courtroom doors and glanced at the case file in his hand. Clara Bennett. Civil dispute. Self-represented. No attorney. Limited assets. He smiled faintly. To most judges, it was a routine matter. To Raymond, it was entertainment. He had built a reputation on humiliating people who entered his courtroom unprepared. Lawyers feared his sarcasm. Witnesses feared his stare. Ordinary citizens feared the sound of their own names spoken by him. And today, he believed, would be no different. Inside the courtroom, rows of wooden benches slowly filled with local attorneys waiting for later hearings, curious spectators, and citizens clutching papers they barely understood. Overhead lights washed everything in a pale institutional glow. At the front of the room stood the raised bench where Raymond ruled like a king who mistook silence for loyalty. Then the side door opened quietly, and Clara Bennett stepped in. No one turned at first. She wore a faded navy cardigan over a plain blouse, sensible shoes, and carried a worn leather folder pressed close to her chest. Her blonde hair was pinned back simply, with a few loose strands near her cheek. She looked like someone who might apologize for standing in the wrong line at a grocery store. A young attorney in the second row glanced at her and smirked before returning to his phone. Two clerks exchanged a look that said the same thing without words. Another easy morning. Clara moved carefully down the aisle, sat alone on the last bench, and placed her folder on her lap. Her hands were steady, but she noticed everything. The exits, the faces, the confidence of people who assumed they already understood her. She had seen that look her entire life. It never changed. Only the suits did. At 9 o'clock sharp, the bailiff called the room to order. Everyone rose. Judge Pierce took his seat and scanned the room like a man selecting a target. When his eyes landed on Clara, they lingered for a beat too long. He opened the file again, then closed it with deliberate slowness. Case number 2147, he said, voice smooth as polished stone. Clara Bennett approached the bench. A hush fell across the room. Clara stood, lifted her old folder, and walked forward alone. Judge Pierce leaned back slightly, already savoring what he believed was coming next. He had no idea that every step she took toward him was a step toward his own undoing. Clara stopped exactly 3 feet from the counsel table and looked up at the raised bench without a trace of panic. Judge Raymond Pierce noticed that first. Most people who stood where she stood shifted their weight, swallowed hard, or searched the room for rescue. Clara Bennett simply waited. Her worn folder rested in both hands, edges softened by years of use, while the courtroom studied her with the casual cruelty reserved for strangers. Raymond adjusted his glasses and let the silence stretch longer than necessary. He enjoyed silence when he controlled it. Ms. Bennett, he said at last, drawing out each syllable. I see you have chosen to appear without counsel. A few attorneys along the side benches exchanged knowing looks. Clara answered in a calm voice. I requested additional time to secure representation, Your Honor. Raymond glanced down at the file, though he already knew every page. He had denied that request 2 days earlier. And yet, he said, here you are. Time waits for no one in this court. Light laughter moved through the room, quick and obedient. Clara did not react. I filed supporting documents regarding financial hardship, she said. They are included in the record. Raymond lifted one hand, as if dismissing dust. Everyone claims hardship when responsibility arrives. More smiles appeared. The clerk at the front desk lowered her eyes, uncomfortable but silent. Clara noticed her too. She noticed everything. The judge leaned forward. Since you have no attorney, you will be representing yourself today. He said it loudly enough for the back row to hear. I trust you understand the disadvantage of that decision. It was not my preference, Clara replied. Raymond's mouth curved slightly. Life often disappoints us. He signaled to the bailiff to remain where he was, then tapped the file again. This matter concerns alleged contractual noncompliance and damages. The opposing counsel has prepared extensively. I hope you have done the same. At the plaintiff's table, a polished attorney named Martin Keene straightened his tie and arranged his notes with theatrical confidence. He had won dozens of cases in Pierce's courtroom, many before the first witness was sworn. Their rhythm was well known in Brookdale. Raymond intimidated. Martin collected. Clara turned her head once toward Martin, then back to the bench. I am prepared to address the facts, she said. Her tone was so even that Raymond felt the faintest irritation. He preferred trembling voices. Facts, he repeated. How refreshing. He removed a gold pin from his pocket and rolled it between his fingers. Before we proceed, let us be clear. This is a court of law, not a place for emotion, stories, or confusion. You will follow procedure precisely. If you fail to do so, I will move forward without accommodating your mistakes. The warning hung in the room like cold air. Clara nodded once. Understood. In the second row, a young law student whispered to his friend, She is finished. His friend nodded. They had seen this performance before. Raymond then asked the question he believed would weaken her publicly. Tell the court your occupation, Miss Bennett. Clara answered without hesitation. I work part-time at the Brookdale Public Archive. A grin passed across Martin Keene's face. Raymond looked almost pleased. An archive clerk, he said. Then perhaps today will be educational. Several people chuckled again. Clara's hands remained steady on the folder. Inside it were neatly tabbed papers, copies marked in blue ink, and notes written in a script so precise it looked printed. She had prepared every night for weeks beneath a kitchen lamp while the rest of the town slept. Raymond lifted the gavel lightly, but did not strike it. Very well, he said. Let us begin. Clara placed her folder on the table, opened it carefully, and for the first time raised her eyes directly to his. There was no anger there, no fear, only patience. And patience, when paired with knowledge, can be more dangerous than either side of the room understood. Martin Keene rose with the smooth confidence of a man who had rehearsed victory more than argument. He buttoned his tailored jacket, carried a polished binder to the lectern, and offered the judge a respectful nod that felt more like habit than courtesy. Your Honor, he began, this is a straightforward matter. My client entered into a restoration contract with Ms. Bennett for access to family records, preservation work, and private indexing services. Payment was advanced. Deadlines were ignored. Materials were mishandled. We seek reimbursement, fees, and damages. He spoke clearly, each phrase landing like a brick placed in a wall already built. Judge Raymond Pierce listened with approving stillness. Clara remained seated, one hand resting lightly on her open folder. Do you dispute these claims, Ms. Bennett? Raymond asked. I dispute nearly all of them, Clara said. The answer caused a few raised eyebrows. Her voice carried farther than before, calm and exact. Martin smiled as though indulging a child. Nearly all, he asked. How precise? Clara turned one page. Precision matters in legal matters. A faint stir moved through the benches. Raymond tapped his pen once. You will address the bench, not opposing counsel. Of course, Your Honor, Clara said. Martin resumed. He presented printed invoices, copies of messages, and photographs of boxed documents stacked in a storage room. To an untrained eye, it looked persuasive. To Clara, it looked assembled. My client trusted Ms. Bennett with irreplaceable family archives, Martin continued. Instead, she failed to deliver and now hides behind technicalities. Raymond nodded slowly. A common tactic. He looked directly at Clara. Do you have evidence to the contrary, or only objections? Clara rose. I have evidence, chronology, and context. The room quieted. Raymond leaned back. Then by all means, enlighten us. The sarcasm was deliberate, but Clara seemed untouched by it. She walked to the lectern carrying only 3 sheets of paper, while Martin stood beside 2 thick binders. Appearances pleased the room. Truth often arrived lighter. First, Clara said, placing 1 page down. The contract submitted by plaintiff is not the final executed version. Martin's smile thinned. That is incorrect. Clara did not look at him. Second, the deadline cited today was amended in writing on March 14th at 6:42 p.m. Third, the storage photographs were taken after I had already been denied access to retrieve completed inventory logs. Raymond's eyes narrowed slightly. You are making assertions. Clara slid a page toward the clerk. Email confirmation from plaintiff's office, time-stamped and authenticated. The clerk glanced at it, then at the judge. Martin stepped forward quickly. Objection to foundation. Clara answered before Raymond could speak. Foundation is attached in the certification page directly behind it, paragraph 3. The clerk turned the page. Her expression changed. Raymond noticed. So did everyone else. Martin cleared his throat. Even if admitted, it changes nothing material. Clara lifted the second sheet. Then perhaps this does. She handed it over. Billing statement from plaintiff's own accountant showing my final invoice marked approved and pending release. Martin's face lost a shade of color. Where did you get that? He asked before stopping himself. Clara finally looked at him. Discovery would have provided it had discovery been allowed. A murmur spread through the courtroom. Raymond struck the bench lightly with his gavel. Order. But the room had already sensed movement beneath the surface. Clara returned to the lectern and opened her folder to color-coded tabs. Your Honor, I would also like to note that I requested records twice and was denied both times. Raymond's jaw tightened. He remembered signing those denials without reading them closely. Requests can be denied for many reasons, he said sharply. Clara met his gaze. Yes, they can. There was no challenge in her tone, which made it land harder. Martin shuffled papers too quickly now. The confident rhythm between attorney and judge had been interrupted. In the back row, the law student who predicted her defeat sat forward with both hands clasped. Clara placed her final sheet on the lectern. And we have not yet discussed the signature discrepancy. The room went completely silent. Judge Raymond Pierce did not move for several seconds. In a courtroom built on routine, hesitation was rare, and hesitation from him was almost unheard of. He adjusted the papers before him with deliberate care, buying time while every eye in the room waited. Clara Bennett stood quietly at the lectern, hands resting beside her folder, as if patience had always been her strongest argument. Martin Keene forced a short laugh that convinced no one. Your Honor, I assume Ms. Bennett is referring to clerical irregularities that have no bearing on the substance of this case. Clara answered before the judge could speak. I am referring to a signature on page for that appears on a document dated April 2nd, although the signer was in Chicago from March 30th through April 5th. The room stirred again. Martin's expression tightened. Speculation. Clara lifted a travel itinerary and placed it before the clerk. Hotel receipt, airline confirmation, and conference registration under plaintiff's own name. The clerk reviewed the pages, then looked up slowly. Judge Pierce extended his hand for the documents. The marble room seemed to hold its breath while he read. Travel records can be misleading, Martin said quickly. People return early. Flights change. Clara nodded once. That would be true, except the same records include meal charges in Chicago at 8:12 p.m. the evening the signature was supposedly witnessed here in Brookdale. A low murmur rolled across the benches. Raymond struck the gavel lightly. Order. But the sound lacked its usual certainty. Clara continued in the same measured tone. Additionally, the witness line was signed by a notary whose commission expired 11 months earlier. Martin turned sharply toward his binder, flipping pages too fast now. The polished confidence he wore at the beginning of the hearing had started to crack. These are minor technical matters, he said. The underlying agreement remains valid. Clara looked at him with almost sympathetic calm. Forgery is rarely considered minor. Silence hit the room like a sudden weather change. Even the bailiff shifted his stance. Judge Pierce's jaw set hard. Ms. Bennett, he said, voice colder now. You will be careful with accusations. Clara met his eyes. I am being careful, Your Honor. That is why I brought evidence. She opened another tab in her folder. Blue labels, neat handwriting, dates arranged in perfect sequence. No motion was wasted. I also submitted motions requesting access to original records. Those motions were denied without hearing. Raymond felt several attorneys glance toward him. He disliked that sensation more than criticism itself. Denied at the court's discretion, he replied. Clara inclined her head. Then perhaps the court can explain why the denials were entered 42 minutes before they were electronically filed. The young law student in the second row blinked in disbelief. Martin slowly lowered his pen. The clerk stared at her screen. Raymond's fingers tightened around the gavel. Where did you obtain that timestamp? He asked. From the public. Docket archive, Clara said. I work there part-time, remember? A few people exchanged stunned looks. The simple archive clerk they dismissed had just used the court's own system against them. Martin tried to recover. Your Honor, this is turning into a sideshow. Clara turned one final page and slid it toward the bench. No, Counselor. This is becoming a record. Raymond read the document and felt heat rise beneath his collar. It was an internal routing sheet bearing initials, dates, and a processing code linked to his chambers. Not enough to destroy him by itself, but enough to raise questions he did not want asked. Clara spoke softly, and because she spoke softly, everyone listened harder. I have spent weeks trying to resolve a billing dispute. Instead, I was brought here under altered paperwork and denied normal process. I would now request that the original filings be examined before this hearing continues. The room went silent again, but this time it was not fear of the judge. It was the first sound of authority slipping. Judge Raymond Pierce had spent 22 years mastering one skill above all others, controlling the room before anyone realized it needed controlling. He knew when to raise his voice, when to pause, when to bury a weak fact beneath a strong tone. But tone had limits, and facts had begun to gather against him like storm clouds over granite. He set the routing sheet aside and folded his hands. This court will not be manipulated by theatrics, he said, each word measured. We are here for a contract dispute, not conspiracy fantasies. A few weak chuckles surfaced and died quickly. No one was sure laughter was safe anymore. Clara Bennett remained standing. Then let us stay with the contract, she said. I welcome that. Raymond felt the room shift again. She was not resisting his frame. She was replacing it. Martin Keene rose too fast, nearly catching his chair. Your Honor, my client has suffered delays, lost opportunities, and reputational harm. Ms. Bennett is attempting to distract from her own failures. Clara turned toward him for the first time in several minutes. Counselor, can you state the date my access credentials were revoked? Martin blinked. That is irrelevant. It is central, Clara replied. Because your damages begin after I was locked out of the database required to complete the work. She lifted another document. Revocation order, signed by your client. 3 days before the deadline you now claim I missed. The clerk took the paper, scanned it, then handed it to the bench without being asked. Raymond read it and felt a pulse rise in his temple. Martin swallowed. Administrative decisions are common in business. Clara nodded. So are consequences. In the gallery, 2 attorneys who had entered for unrelated matters quietly closed their briefcases and stayed seated. They no longer wanted to miss whatever this had become. Raymond straightened in his chair. Ms. Bennett, enough speeches. Present concise facts or sit down. Yes, Your Honor, she said pleasantly. Concise fact 1. I completed 78% of the contracted indexing before access was revoked. Concise fact 2. I repeatedly requested reinstatement. Concise fact 3. The plaintiff invoiced private donors using progress reports generated from my work product while claiming I had done none. A hush fell so complete the fluorescent lights could be heard faintly humming overhead. Martin's face lost color. That is false. Clara slid forward printed fundraising letters bearing dates and language identical to her archived summaries. Then your client copied my phrasing by coincidence. The young law student in the second row slowly whispered, No way. His friend did not answer. Judge Pierce looked toward Martin with irritation usually reserved for defendants. This case was supposed to be simple. It had been selected for speed, not scrutiny. Counselor, Raymond said coldly, were these materials disclosed? Martin hesitated half a second too long. They were not requested specifically. Clara's eyes never left the bench. I requested all donor communications tied to the project on June 12th, June 19th, and June 26th. She raised 3 certified mail receipts. signed for each time. Raymond knew that pause from lawyers. It was the pause of someone searching for a door in a room. With none, he attempted one himself. Even if true, these matters may be addressed separately. We proceed today with narrow issues only. Clara closed her folder halfway, as if preparing to leave. If the court prefers narrow issues, then I request a ruling on why altered exhibits were accepted while authenticated records were excluded. The room went still again. Raymond's throat tightened. She had said it plainly now, where stenographers typed every syllable. Martin lowered into his chair without grace. The clerk's fingers hovered over the keyboard, then resumed. Clara reopened the folder and withdrew a final envelope, sealed, organized, and marked with dates. I also brought certified copies from the State Archive Division, she said softly, in case anyone questioned my memory. Judge Pierce stared at the envelope as if it might open itself. Power had protected him for years because most people arrived frightened, rushed, or alone. Clara had arrived prepared, and preparation is what arrogance fears most. Clara Bennett held the sealed envelope with the same calm grip she had carried since entering the courtroom. But now even the smallest movement drew attention. Judge Raymond Pierce could feel it. The room no longer looked to him first. Eyes followed her hands, her papers, her pauses. Authority had not disappeared, but it had been questioned, and once questioned, it never returned unchanged. Submit it to the clerk, Raymond said, aiming for steadiness and finding only strain. Clara walked forward and placed the envelope on the clerk's desk. The clerk broke the seal carefully, removed 3 certified packets stamped by the Commonwealth Records Division, and passed the first set upward. Raymond reviewed the cover page, then slowed. His practiced expression nearly held, but not completely. The documents were chain of custody certified copies of electronic filings, access logs, and revision histories tied to the very case before him. Clara spoke in a voice so measured it made every sentence sound heavier. Those records identify when exhibits were uploaded, who modified them, and from which terminal the changes were made. Martin Keene rose halfway from his chair. Your Honor, I object to relevance and foundation. Clara answered without turning. Foundation is page 2. Relevance is the reason we are all still here. A few people on the benches exchanged startled glances. Even now, she was respectful without yielding an inch. Raymond read further. A timestamp glowed on the page like a warning light. One plaintiff exhibit had been replaced at 7:14 a.m. that morning. Another had metadata showing edits from a terminal assigned to Chambers staff. He set the papers down more quickly than intended. There are often administrative corrections, he said. Clara nodded once. Then the court should welcome transparency. The clerk lowered her eyes to hide a reaction. Martin cleared his throat. Minor formatting updates do not affect substance. Clara lifted another packet. Then perhaps this one does. She handed it to the clerk, who passed it up. It contained emails obtained through a lawful records request. Raymond scanned the first page and felt the blood leave his face. Martin's office had coordinated exhibit numbering with a court assistant before motions were ruled upon. No explicit misconduct. Nothing dramatic. But enough to suggest favoritism, enough to invite review, enough to make headlines in a town that fed on quiet scandals. The room sensed change even without reading a word. Ms. Bennett, Raymond said, voice lower now. How exactly did you prepare this presentation? Clara folded her hands. The same way honest people prepare for difficult rooms. I read carefully. Silence answered her. Then she added, I also attended law school. That landed harder than any accusation. The young law student in the second row sat back in disbelief. Martin stared openly. Raymond blinked once. You are an attorney? He asked. No, Clara replied. I graduated first in my class 15 years ago and chose public records work instead. I never sought a license because I preferred service over spectacle. The room went still in a different way now. Not suspense. Respect. She continued softly. But I never forgot procedure. Raymond's mind raced through every dismissive remark he had made that morning. Every laugh he had allowed. Every denial signed too quickly. Martin looked down at his own table as though it belonged to someone else. Clara opened her folder one final time. I move for dismissal with prejudice, sanctions for altered submissions, and referral of all filing irregularities to the State Judicial Conduct Office. She said it plainly, without flourish. The stenographer typed faster. Raymond glanced toward the gallery doors as they opened quietly. Two individuals in dark suits entered carrying identification badges from the administrative office of the courts. They did not hurry. They did not need to. The bailiff straightened instinctively. No one spoke. One of the officials approached the clerk and requested the case file. The other looked directly at the bench. Judge Pierce had spent years making people feel small from that elevated seat. Now, for the first time in a very long time, the height beneath him felt dangerously temporary. The two officials from the administrative office of the courts moved with the calm efficiency of people who did not need to announce authority because they carried it naturally. One requested access to the electronic docket terminal. The other stood near the clerk's desk reviewing the certified packets Clara Bennett had submitted. No one in the gallery reached for a phone. No one whispered loudly now. Even curiosity had become careful. Judge Raymond Pierce cleared his throat and adjusted his robe. "This hearing will recess for 10 minutes, he declared. His voice aimed for command, but it arrived thinner than before. Clara spoke before anyone rose. "Your Honor, before recess, I ask that the pending motion for dismissal be entered on the record." Raymond's jaw tightened. She was forcing every step into daylight. "Noted," he said curtly. The stenographer typed without pause. Martin Keene remained seated, staring at his own binder as if the pages might rescue him. They did not. One of the officials looked up from the filings. "Judge Pierce, please remain available after proceedings conclude." The wording was polite. The meaning was not. A hush rolled through the room. Raymond gave a stiff nod. He had once enjoyed making others feel publicly diminished through simple phrases. He now discovered how sharp simple phrases could be when directed upward. 10 minutes later, the courtroom reconvened, though nothing about it felt the same. The side conversations were gone. The easy smirks had vanished. Clara stood at her table, reorganizing papers she no longer needed. Martin returned with a sheen of perspiration at his temples and none of his earlier swagger. Raymond took the bench again, but the height beneath him seemed ceremonial now. "Counselor," he said to Martin, "does your client wish to proceed?" Martin rose slowly. "Your Honor, after reviewing newly presented materials, my client seeks voluntary withdrawal of claims without prejudice." Several people exchanged looks. It was the legal version of retreat while pretending to choose the direction. Clara lifted her eyes. "I object." The single sentence landed like a bell. Raymond stared at her. "On what grounds?" "Because false claims were filed, altered exhibits were used, and I incurred costs defending myself against conduct now conveniently abandoned." Her tone never sharpened. It did not need to. Withdrawal without prejudice invites repetition. Accountability requires finality. The law student in the second row scribbled that sentence into his notebook as if it were worth tuition. Martin tried again. There was no bad faith. Clara opened one page and held it up. "Then why did your office bill donors for completed archival milestones while suing me for failing to complete them?" Martin's mouth opened, then closed. Raymond looked down, not at her, but at the paper. He already knew there would be no good answer. One of the court officials quietly requested a copy for the file. Martin sat down. It was not graceful. Raymond removed his glasses and polished them with unnecessary care. Delay had become his final instinct. "The court has considered the matter," he said at last. "Claims are dismissed with prejudice." A wave of silence followed. He continued, each word sounding more expensive than the last. "Plaintiff is ordered to reimburse documented defense costs within 30 days. Alleged filing irregularities will be referred for independent review." Martin closed his binder with trembling hands. Clara did not smile. Vindication had no need for celebration. Raymond then turned to her, perhaps hoping to reclaim something human in the room. "Ms. Bennett, you may submit cost documentation to Chambers." Clara met his gaze steadily. "I prefer to submit it through proper public channels." A few heads lowered to hide reactions. Respectfully spoken, but unforgettable. The official nearest the bench stepped forward. "Judge Pierce, when this session concludes, we need your immediate cooperation regarding administrative inquiries." Raymond nodded once. There was nowhere else to look. Clara gathered her worn folder, slid each paper neatly inside, and fastened the clasp. The same folder many had dismissed now held the collapse of two reputations. As she turned to leave, the gallery instinctively made space for her. Sometimes people step aside for power. Other times, they step aside for dignity. The courthouse doors opened with their usual heavy dignity, but the atmosphere beyond them had changed completely. Clara Bennett stepped into the marble corridor carrying the same worn leather folder she had brought that morning, yet it seemed lighter now. Not because the papers weighed less, but because truth often removes burdens that fear cannot. Behind her, courtroom 3 remained unusually silent. No quick footsteps, no smug laughter, no casual chatter from attorneys who had once treated the room like a private club. Inside, Judge Raymond Pierce still sat at the bench while the two officials organized documents, requested login credentials, and quietly asked for chambers access records. Every sound in the room had become practical. Printers hummed, keys clicked, pages turned. It was the sound of systems examining themselves. Martin Keene lingered near counsel table, packing his expensive binder with the slow motions of a man realizing that confidence borrowed from others expires quickly. He glanced toward the gallery and found no sympathetic faces. The lawyers who once admired his easy victories avoided eye contact. Reputation, he learned, leaves faster than it arrives. In the hallway, Clara was stopped by the young law student from the second row. He clutched a notebook to his chest and looked both embarrassed and sincere. "Ms. Bennett," he said, "I owe you an apology. I judged you the moment you walked in." Clara studied him kindly. "Then learn from the moment," she replied. "Many people never do." He nodded, writing nothing this time because some lessons are remembered without ink. Farther down the corridor, the court clerk from inside the room approached quietly. Up close, she looked younger than Clara first assumed, tired in the way honest people often look in dishonest places. "I wanted to say thank you," the clerk said softly. "Some of us notice things for a long time." Clara's expression warmed. "Noticing matters," she said. "Speaking matters more when you are ready." The clerk's eyes filled, but she steadied herself. Behind them, the courtroom doors opened again. One of the officials emerged and spoke to a security supervisor in a low voice. Another staff member carried out 2 archive boxes labeled Chambers Correspondence. The hallway fell silent as employees pretended not to stare. Judge Pierce did not come out immediately. Men who build identity around titles often need extra time when titles loosen. Across town, by noon, whispers had become phone calls, and phone calls had become certainty. The Brookdale legal community moved news the way wind moves through dry leaves. By lunch, partners at firms knew Martin Keene's filings were under review. By 2 o'clock, reporters had requested public records. By 3, donors connected to the plaintiff's project were asking pointed questions. Consequences rarely travel alone. Clara, however, did not head toward cameras or attention. She walked 3 blocks to a modest cafe with fogged front windows and ordered black coffee and a toasted bagel. She chose a corner seat beside the glass and opened her folder one last time. Inside were tabs, notes, receipts, and years of discipline hidden beneath ordinary appearances. She removed a small framed photograph tucked in the back sleeve. It showed Clara much younger beside an older woman in graduation robes, both smiling into bright spring sunlight. Her mother had once told her, "Never confuse being overlooked with being powerless." Clara touched the frame gently before returning it to the folder. Outside, people hurried past without knowing who sat by the window. She preferred it that way. In the courthouse, names on doors were already being discussed. In the cafe, no one recognized her at all. And still, she was the strongest person in the city that afternoon. Some victories need applause. The finest ones simply continue walking. By the next morning, Brookdale woke to a city that sounded the same but felt different. Traffic still moved past the courthouse square. Coffee shops still opened at 6. Delivery trucks still rattled over brick streets. Yet beneath the ordinary rhythm, people carried the quiet excitement that comes when power has finally been forced to answer questions. The local paper did not print names on the front page, but it did run a headline about administrative review, filing irregularities, and emergency oversight measures inside the county court. Everyone knew exactly which courtroom it meant. Judge Raymond Pierce did not appear for the morning docket. A temporary replacement handled proceedings with careful courtesy that startled regular attorneys more than any scandal had. People who once stood trembling at that bench were greeted with patience, clear explanations, and actual listening. It was astonishing how revolutionary basic respect could feel. Martin Keene's office released a short statement about cooperating fully and reviewing internal practices. It was polished language for a rough day. 3 clients quietly moved their business elsewhere before lunch. 2 donors requested reimbursement records tied to the archival project. By sunset, his name no longer opened doors the way it had a week earlier. Reputation, once cracked, makes a distinct sound. Clara Bennett returned to work at the Brookdale Public Archive just after 9. She wore the same navy cardigan, carried the same worn folder, and greeted the receptionist with the same warm smile she always had. The receptionist looked at her as if seeing a hidden landmark for the first time. "You were incredible yesterday," she whispered. Clara set down her bag and smiled gently. "I was prepared yesterday." Then she added, "There is a difference." In the reading room, sunlight filtered across long wooden tables and rows of county ledgers older than anyone alive. Clara moved among shelves of deeds, census rolls, maps, and court minutes with practiced ease. She loved places where facts were preserved whether people liked them or not. By noon, the young law student from the courtroom arrived carrying a small bakery box and too much nervousness. "I brought muffins," he said awkwardly. "And a question." Clara laughed softly. "Those are rarely equal offerings." He asked if she regretted never becoming a licensed attorney. She considered it while straightening a stack of property records. "No," she said. "The law is not only practiced in courtrooms. Sometimes it is protected in archives, classrooms, kitchens, and conversations where fairness is chosen." He stood silent, taking that in. "Then why fight yesterday?" he asked. Clara closed the ledger before her. "Because silence can be noble," she said, "but not when it helps dishonesty." He nodded slowly, understanding more than when he arrived. Later that afternoon, one of the court officials visited the archive to request certified copies of old procedural manuals. He thanked Clara for her professionalism. She accepted the gratitude politely and returned to work. She did not ask what would happen next to Raymond Pierce. Some endings do not need witnesses. Near closing time, Clara stepped outside carrying a grocery bag and her old folder. The courthouse dome glowed gold in the lowering sun 3 blocks away. People entered and exited its doors, each carrying worries, hopes, mistakes, and paperwork. Institutions would